All right, well, tell me about the Allendale with
I'm sorry, Your Honor.
the murder weapons.
That's the first I've heard of that. I have never heard the first thing about that. If somebody told me that they had matched that to the murder weapon, not only the first call again I would be making would be to them, and the second call I'd be making would be to Your Honor. That is the first I've heard of that. I've never read the Fitz article. Certainly nobody at SLED, who I communicate with on a daily basis, has said, hey, Creighton, by the way, X happened. So I will certainly look into that, but I would be flabbergasted to find out that actually had happened and no one had advised this office of that.
Okay. All right. I hope that answers your questions. He's going to get back with you. He's going to double check on Agent Kelly. But to his understanding, there was no dishonesty, but that would raise the bar to Giglio.
Yeah.
But he's going to get back with you. As far as the murder in Allendale with the murder weapons, you certainly raised my eyebrows on that.
Your Honor, throughout this case, Fitz News has been breaking stories that we were unaware of. And we can go through a long litany of that. But there was a podcast, there's a reference to what I just said to you.
Maybe you could forward that to Mr. Waters and let him look at it and see if there's anything to it.
But we would ask that they look into that.
And I'll be the first to say, Your Honor, is that I don't watch the podcasts and I don't read the blogs. I try to base what I'm doing on the evidence and not on speculation that's out there in the media. But I've never heard of that thing, and I will make inquiries. But it would blow my mind if something like that had happened in SLED and not call me. I communicate them daily. Their general counsel sitting here in the gallery here today.
Should. I'm just saying
Right.
we're examining that, and that's why I'd like till the 1st of November. And of course, in the question, if you do a questionnaire, when they get here, obviously we want to know a little bit more about their specific knowledge of the case. But so yes, we agree there needs to be a questionnaire. We may want to add some questions to that questionnaire. We're just not sure, but we will be by the 1st of November.
And what we did last time, Your Honor, that worked very well is we had that questionnaire. The parties went through that questionnaire. We actually then had a dialogue where we agreed based on certain responses of jurors to exclude. And so they were already gone by consent, but we already identified ones that would need additional questioning. And then, of course, there was additional questioning with the court and the parties in private for either jurors by their questionnaire or by responses in court that just needed further inquiry. And again, we were able to do that in 2 days.
And Your Honor, we would ask that there be direct supervision by you of the issuance of the jury summons, how they're picked. There were huge questions, obviously, after we learned of the clerk's conduct about how certain people maybe got on the venire and others did not. She was apparently excusing people, we believe, and of course this litigation would help us. Litigation that's on appeal, of course, we're going to let us develop that. Her daughter appeared on the jury venire, and she, and I guess at the time, either I nor Mr. Waters thought that was unusual, but she was talking to both of us about how she makes a great juror. She talked to me, I know she talked to you. I'm not saying expecting that to happen again. We've got a new clerk, but in terms of summonsing jurors, there's a process. The Supreme Court, I found out later on, that there's a list. Actually, they're generated in Columbia. And then the clerk excuses, before he or she issues those summons, there's a screening process. That's what I'm concerned about. In other words, the big list will come from Columbia, but how it gets narrowed down before we ever see it, that would be me
Right.
and Mr. Waters, concerns me greatly.
Again, this is the first that I've heard of any issues with that. I mean, my understanding is with Judge Newman's supervision, obviously a number of ones that were excused based on, patent exemptions such as over 65 who claimed that were non-residency issues and that sort of thing.
Right. That would be my understanding of what normally happens
And when we
pick a jury here.
We had the whole panel arrive. Yes, there was something like that. Obviously, she was excused. There were also people that had close relationships with with Alex Murdaugh and the Murdaugh family. And of course, we vetted all of that and excused as appropriate.
Well, but what was never done, and I tried to get the list, compare the initial list that was generated in Columbia to what actually were summons that were issued and certainly there were people that the clerk said,
They don't live here. They're over
Right.
65.
dead, whatever, I get that. But if we never got the original list, so we don't know, and again, call me suspicious, but when we have evidence that the clerk of court is attempting to influence the jury to obtain a guilty verdict so she could sell more books, when did that start? Did it start when she started winnowing down people she thought might be helpful to us? And I'm not saying that could happen again, but I think I need to say to the court, I never expected it to happen the first time. I've been doing this 50 years. I've never seen a clerk of court interfere in this process. And clearly our Supreme Court found she did.
Okay. Well, I can tell you, Mr. Harpootlian, I certainly don't mind overseeing it.
Thank you, Your Honor.
That's for sure.
And again,
Mr. Waters,
this,
I will, wherever this trial is going to be, I will certainly make sure that it is on the up and up. I can promise you that.
and just to be clear, there's absolutely no evidence that there was any shenanigans with that part of the
Yeah,
process.
I haven't heard of any of that, but, we'll just make sure that everything is done properly.
Thank you, Your Honor. That's all I'm asking. And again, I would agree, we were never allowed to look at that piece of it for our motion for a new trial. It wasn't relevant to that. And the clerk was not going to, she never admitted she talked to any jurors. The court, both Gene Toll and the Supreme Court found her to be a horrible liar. So you'd have to prove it extrinsically. We don't need to go there. We may go there in our federal case, but we don't need to go there. I'm just saying, call me naive. I just want to make sure that you are in charge of this process. And it's not deferred to some functionary.
No, I don't have a problem with that.
Thank you, Your Honor.
All right, the next
Very quickly,
motion.
if I could
Oh,
just
yes.
say that as we got the dumps from the clerk's office with the jurors, it had the numbers on there with the over 65s and had the return from those individuals.
You did get those?
That's my
We
recollection.
did, but the question is, who got off that list before we got it?
Okay.
That's the problem. And do we have any
You
evidence
just
of
want
that?
the original list.
I want the
is what you
original
want.
list, and I want you
I understand.
I want you to have the original list. So when the summons go out, you know that everybody was on that summons list was summoned unless you were told they were dead, and again, I'm a little paranoid after our last experience, not realizing the clerk was trying to fix the jury.
Okay. Well, I will, I'll make sure I speak with the clerk before that process.
And Your Honor, certainly Mr. Waters is not vouching for her veracity and truthfulness here today. I understand that we're here because she attempted to fix the jury, right? Am I
I think
missing
he
something?
I think he understands. Let me hear from you, Mr. Waters.
Well, look,
I
there
think
is
he
absolutely
understands
no
why we're
evidence.
here today.
I went through a lot, and
A polygraph. And as Mr. Waters knows, in other words, he had a deal, and the deal was predicated on him passing a polygraph. This is a copy of the results of that polygraph. And the polygraph was, did you kill Paul and Maggie Murdaugh? He failed it. And so they, relying on that, canceled his proffer agreement. Now, I'm not saying necessarily that's admissible on cross, but I am saying that it's an issue, not now, but much closer to trial, that we need to be able to litigate. And there may be others. We're going back through, I will tell you, Mr. Murdaugh passed a polygraph, flying colors. So, the same polygrapher. So, it may play a role in this trial. I'm not willing to concede that not under any circumstances can a polygraph ever be used. I'm just giving you this example of Eddie Smith failing the polygraph and them relying on it to cancel his deal. Now, that's what our understanding is from the limited documents. They never called Eddie Smith in the first trial, which we were shocked by. But should they call him in the second trial, we may want to go into this. So I would ask you not to issue an order prohibiting any mention of polygraph with this guarantee. We would not mention polygraph in a courtroom with a jury until given permission by Your Honor to do so.
All right, well, let me tell you, anything else from the, Mr. Waters?
Well, Your Honor, just to correct one thing, there's never been any sort of deal with Eddie Smith. A proffer is not a deal. It says in big bold letters, this is not a cooperation agreement. It's only, essentially a first aid provision. Again, polygraphs can be an investigative tool, but they are never, I never base decisions on them. And frankly, in my experience, I found them to be wrong or for people to indicate DI for other emotional reasons than them to be accurate. This is why they're not ever relied upon in court.
Well, that's going to be my ruling, Mr. Harpootlian. I'm going to rule that the results of a polygraph examination are not admissible, as well as the defendant's willingness or refusal to submit to a polygraph. And I'm going to tell you now, there is to be no mention of a polygraph test before the jury. This ruling is based on counsel and case and the Palmer case. Should the defense seek to introduce any evidence or testimony or reference concerning a polygraph examination, you must notify the court and obtain a ruling outside of the presence of the jury, or risk this case being a mistrial. You understand?
Well, I think, Your Honor, you're probably
Thank you, Your Honor.
Any response, Mr. Waters?
Very briefly, Your Honor. First of all, just because I just got this from General Counsel at SLED, that there was a 300 blackout that was used in Allendale. However, it was entered into IBIS, and there have been no leads or no matches on that. So that's what I was just informed.
Is that going back to
The prior motion,
to
yes.
the prior where the blackout was
And I'll find out more, but it
said to have been used in another murder in Allendale or somewhere? You understand that, Mr. Griffin? Okay. You know, sometimes a real novel idea is to pick up the phone and call each other and talk. That's what we used to do when we were young.
Sufficient to meet that burden.
Okay. All right. Well, I've read the case law. I've read the statute in this case, and I think it's pretty clear. A criminal defendant's testimony from a first trial is admissible at a retrial in the same case, and that is from 1911-50. The testimony of a defendant in a criminal case shall not afterwards be used against the defendant in any other criminal case. That is, our Supreme Court interpreted 1911-50 narrowly, and it limited its protection to the use in a different criminal case, not the same case. So I believe that his testimony may come in under 804. I've got B1 or A1, I think it's B1, or for impeachment purposes. The court does not find the defendant's argument prevailing. I think you rely heavily on Harrison versus U.S., where the defendant was forced to testify as a result of the prosecution using illegally obtained confessions by the defendant. Here, the defense argues that the evidentiary decision of the trial judge to allow evidence of the financial crimes coerced the defendant into testifying. However, I went and looked at the ruling again from our Supreme Court. The court ruled that the evidence of the financial crimes in this case is admissible in the new trial, so long as it is probative to the murder.
And in addition, what Othram can do, so we do know that this sample, this is male, the unknown male. So there's Y chromosome in that sample. Othram can test and analyze that Y chromosome, and depending on how much it is, they can go back to origin. Like, is it an Asian? Is it a white male? Is it, and they're able to do that. And so they have so much more capacity than the SLED lab. And it's expensive, and we're wasting time, and we want to pay for it and we want to get on with it.
Well, I already told you I'd let you pay for it. That's a given. That's going to happen. How long is it going to take them to do it?
Well, we put in our supplemental memo that it would take 60 to 90 days. I mean, honestly, he says, we'll make it a priority. We can do it in 60 days. And I said, well, how about, don't say that. Let me say 90 days. But what we'd like to do is have it all at one time so we can do it all at one time.
I understand that. But let me ask you this. What does your expert say about having something left over that they can give and share with the state? Do they think if they had it all, is there something going to be left over to give to the state? So they want to do their STR test again.
So we would know that, Your Honor, after the quantitative analysis that we would like Othram to do. And then we would like to share that with the SLED lab. There's no reason, because they're doing the same thing. And Othram says, why?
Well, if you're going to share the STR results, you're going to share the SNP results?
Well, Your Honor, I didn't say we was going to share any results. I mean, I said they could do that. The rule doesn't require us to share results from scientific analysis unless we intend to use it. But
Right, I agree with you on that. But I'm asking if they wanted, you volunteering to do the STR, which they want to do also.
well, I'm not sure they want to do that, Your Honor. I haven't heard that. I've said, to what end do you want to use this after doing a quantitative analysis? Well, what are you going to do with it? You going to do the same thing twice? You expect a different result? I promise you they're not going to do that, because then that would pretty much cause their lab to be, the credibility to be challenged at that lab. They do the same test, get two different results. I mean, we're talking about the same sample, Your Honor. We're not, and they know the mixture. And they tell us the mixture is 99% Maggie Murdaugh and 1% unknown male. So, I mean, they've got that information. But we'll do the quantitative analysis. We'll come back and, share that with.
Trial, we want to.
Yeah, you have somebody from SLED here that can tell me about, if I give them this sample, you can't do an STR?
We do have Lieutenant Stanley from SLED.
Come up here and speak with me, but I'm going to put you under oath. Madam Clerk.
You solemnly swear or affirm that the testimony you give the court is the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Okay. All right, well, tell me how you lose your accreditation if I give them a sample and then you take the leftovers and, yeah, you can go right there at the podium. And you can't produce an STR that could be admissible in court. Is that what you're telling me?
Good morning, Your Honor. I am the quality manager for the laboratory, so my job is our accreditation and making sure that we are complying with accreditation standards. The DNA laboratory is accredited by the same entity as Othram, but in different capacities. We also follow the FBI Quality Assurance Standards, or FBI QAS standards, that are put out by the FBI for DNA caseworking or testing laboratories, as well as DNA databasing laboratories. In order for us to accept data from, or accept a sample from another laboratory, they need to be accredited in the same services for us to continue our testing. So it's not necessarily losing accreditation, because we just wouldn't be able to accept it and perform the testing.
Well, let me ask you this. What if you got a sample and it was the only sample you had that had already been processed? Just hypothetically, are you going to tell me that you're not going to do an STR on it and try to admit it into court?
We may not be able to, is what I would like to tell you. We share samples with Othram, for example, or third-party laboratories, but we're typically giving them the extract or the remaining portion, and they're able to work with that for their samples. We are unfortunately not able to work with theirs.
Why?
I'm not as familiar with the SNP testing, so that might, my understanding of that is it has to do with the standards that are followed for the accredited laboratories.
Okay. All right, thank you. Mr. Griffin, let me ask you this. If I give you the leftovers and I give you the unprocessed sample, you have it quantitative and you do your SNP test, and then you give them the leftovers, and they can do their STR test, would you consent to it being admitted into court?
Yes, Your Honor. We wouldn't raise any objection as to the
To accreditation or
accreditation, chain
anything
of
like
custody,
that?
thing like that. Now, if there's some other irregularity in the process, sure, but not because of it flowed from Othram back to SLED. No, we would back and forth. But what we don't want is SLED to keep it, SLED to do a quantitative analysis, and then say there's not enough for you to use. I mean, that's what we don't want.
That's my whole offer, is I wouldn't proceed without having that discussion and with him. So that's the whole point of what I've made, is that we'll know what we have at that point. I'm not going to do anything to prejudice anybody, but we got to process it to know exactly what we have and what we can do with it.
And we want to process it.
I understand. Griffin, I'm gonna grant your motion. I'm gonna let you, take it. The leftovers, the new, y'all make sure you make a chain of custody. I'm gonna let you, have the analysis done quantitative, then I want you to report back to the court and tell me if there's leftovers before you do your SNP test. I want to know beforehand, and then, because I've got to get this started. You need 90 days at least. So we need to get it started. I want you to report to the court, let me know, and then I'll have a discussion with y'all on what we're going to do.
All right, thank you.
It all. But if you would put your position on the record for me.
Okay, well, the 14th Circuit, which is Colleton, Jasper, Beaufort, and Allendale, is where the defendant is from, where his law firm has operated for 100 years. The Murdaugh name is well known throughout that entire circuit. And so that circuit, the movies that were filmed, the 5 movies that were filmed in Colleton, Jasper, and Beaufort. The Murdaugh case is a local freak show. You have people being interviewed on the street in all those counties, commenting on whether they thought he was guilty or not, or whether this happened or that happened. I mean, it was so outrageous that Buster Murdaugh is suing Netflix for accusing him of murder. That's a civil case that's going on in Hampton County. So there's no, I mean, do we have the money to have some sort of poll or do what they did in the Parker case? No. And that's why I want to rely on what they found in terms of their ability, Parker's ability, to get a fair trial in this community that's permeated with this pretrial publicity, the movies, the books, 6 books on this, and many written, a couple of them written by folks down there other than from their jobs. And I mean, it's going to be tough. Getting a jury in this case is going to be extraordinarily difficult. Why make it more difficult by limiting your choices? Why make it more difficult? Because, and again, There's no tactical advantage to us in Charleston. He's not from Charleston. I'm not from Charleston. The Charleston is going to give us a larger jury pool that's more accessible to 30 or 40 witnesses in this case from Carleton County. So you know, when you look at the cases on this issue, they all come back, and I understand they have a right to a fair trial too, but he has a Sixth Amendment right to a fair trial. And that Sixth Amendment right means, and let me say this to you, you know what else you get with Charleston? No appeal. I'm putting on the record, if you give us Charleston, we will not appeal the venue issue, ever. Take that one off the plate. Not that
You're
you,
requesting the change of venue.
I know.
Just want to make sure I've got that right.
If you deny the motion for change of venue, we're going back to Carleton. So I don't really think, and correct me if I'm wrong, that that is a viable alternative. I think we've got to move it somewhere. And we're suggesting Charleston because we think that will be the most expeditious way to get a jury that truly has not made up their mind.
Okay.
Now, he's arguing cost. I heard him. He's trying to get Mr. Barber to say Charleston is expensive. And when I'm there, not on business, well, sometimes on business too, I stay at really nice hotels and eat in really nice restaurants. But we won't be for this. He's broke. He hadn't had a job in 4 years. And if he did have a job, the feds or the state would be seizing the money. So, and we have and let me say this, we have an office in Charleston within walking distance of the courthouse. So that makes it more economical for us and allows us to have the money to hire a DNA laboratory in Texas. And we're going to have to hire other experts from outside the state. And we want to put our money into that, you know, not having to stay somewhere else or even paying for witnesses to have to come somewhere else. Now, our memo talks about, you know, all kinds of things and the factors. But Your Honor, first of all, I would say to you, if he gets up here and argues we need to go back to Carleton County, then he is, and I don't know why he would do that. I have no idea why he wants to go back to Carleton County. Maybe it's his lucky courthouse, but it's not rational and compared to what his Sixth Amendment rights are.
Okay.
Happy to answer any questions you have.
And the surrounding litigation. The court concluded, other than publicity, the settlement of the wrongful death action, the criminal prosecution of Mr. Murdaugh, the defendant in this case, including his reversal by the clerk of court. The same publicity and public attention that justified transfer in Beach is present here and further supports this court's determination of a change of venue is necessary to protect the defendant's constitutional rights. Further, I'm going to find that under Section 172185 is not an adequate alternative. That procedure would require Carleton County to bear the substantial cost of transporting, housing, feeding, and securing an out-of-county jury throughout a multi-week trial. More importantly, it would not remedy the prejudice identified by this court or eliminate the concerns arising from retrying this case in the same community where the constitutional violation occurred. I find that there's no lesser remedy that will adequately protect the defendant's constitutional right to a fair and impartial jury. The court rules venue is transferred outside of the 14th Circuit. I'm going to reserve my ruling to the specific county in which this matter will be transferred. You know, let me tell y'all, it takes a village to get this case transferred. For those of you who don't know, there's a lot of other things besides walking into a courthouse and sitting down and trying to try a case. You know, we have to consider security, transportation. Is the courthouse adequate? Is there lodging? There's also docket considerations that have already been set for next year. There's a bunch of matters to consider. So what I'm going to do is I will think about it. I need to look at it. I will tell you, Mr. Waters, you are correct. Cost is a concern because Colleton County does bear the cost of the retrial in this case. Colleton County is not a rich county. It's a poor county. So that will be at the foremost of my thoughts when I transfer this case. I was in hopes that the two of y'all could agree on a destination, but since that's not happening, I will decide and I will let y'all know. I will issue an order. I will do a formal order on my transfer of venue and also will designate the county into which we are going to try this case. Okay? Any objections?
None from the state, Your Honor.
Perfect.
Thank you, Your Honor.
You're welcome. All right.
Camera proceedings and the only person who was removed from the jury. But I certainly will respect your ruling.
Well, if someone else decided to run their mouth and go to the media, then that's on them. It ain't on us.
Good.
I would also point out, Your Honor, that Mr. McCullough on June 24th, June of 2024, requested unsealing of the in-camera proceedings and then filed on September 4th, 2024, a petition to intervene with the Supreme Court to seek it unsealed. So on multiple occasions, he has requested to have it unsealed. So,
And I achieved my goal, which was to have access.
Look, I like for everybody to know everything. So this is the deal. We're going to unseal it. We're going to protect the jurors' names. I want that redacted. I want any identifying information concerning a juror redacted. Unseal the rest of it.
Thank you, Your Honor.
That's exactly what the state wants. Thank you, Judge.
Thank you.